This meeting is being recorded.
Hello, everyone, and thank you all so much for joining us on our weekly Friday webinars. Today, I am joined by our awesome managing attorney, Ruby Powers, and we are here to discuss how to successfully respond to RFEs, NOIDs, and NOIRs, so NORs. It's a weird thing to say. Just some quick background information on our attorney. She has been licensed since 2008 and is a board certified immigration and nationality attorney. Attorney Powers, do you want to take it away?
Yes, this is a topic that is really important because either a person might have filed on their own or with maybe a friend or somebody, or maybe they hired somebody who was an attorney to help them fill out information, or maybe even they have an attorney and they got one of these. And so it's just really important because when you see these in the mail, it's just a tendency to get very heightened, alarmed, and concerned. Especially as you go down the list here. And so we just wanted to walk through some of these. And, as we always say, this doesn't take the place of legal advice, but we wanted to help empower you with information. And you can always take it to an attorney to talk further about your situation. So request for evidence, notice of intent to deny, notice of intent to revoke. So at the time of this recording in February 2022, we're still allowed to do responses and have a little bit more availability to respond, even though the date on the notice might say you have only this much time. There is an even updated more than the one that we're showing here on the screen that was recently updated as well, that is inclusive of right now. And it basically says that for requests for evidence, you will have USCIS will consider a response to the above requests. So all requests for evidence, notice of intent to deny, notice of intent to revoke, notices received within 60 days after the response due date set in the request. So if it says, let's say January 15th is the due date, then you have another 60 days because of this extension that's being the leeway flexibility for during COVID times. Now, this is not normal. We've only had this for about 2 years because of COVID. And so one day they're going to take it away. Who knows when, but so that does give us some leeway. So additional 60 days added to the date that they usually give. Now, if you have never done this and you're doing this on your own, I would say read the most recent memo and triple check yourself that you're reading it right. And then when we do respond, we also say whether we're invoking it or not. So that way it's clear on the cover letter. And sometimes we even give the latest printout because it could be adjudicated at some point later when that policy might not be in place anymore. All right, what's a request for evidence? RFE. We usually call them just RFE. Just saves a few syllables of breath, but it can be another acronym. So USCIS has a discretion to review, and they could deny without lack of initial evidence. That was really an interpretation a lot under Trump administration. Under Biden, they're a lot more flexible, and we really haven't seen a denial without an initial request for evidence or notice of intent to deny initially. So bottom line, you're supposed to send certain things for certain applications. And if there's something missing, maybe it really was on the person who submitted its error, or maybe it's just something that the USCIS wants to see more of or updated, then they'll ask for it. So request for evidence. That's pretty much it. Now, it usually will tell you how long you have. If sometimes it'll be 33 days. Sometimes it might be 87 days, but ultimately they'll tell you. Now, you don't want to get requests for evidence because it's more work and then it delays things. So you want to try to avoid them, but sometimes you just can't. So, but while you try to resolve it as timely as possible, you want to make sure that initially you try to make your application as complete and full in the first time you go. So try to make sure that you don't trigger the RFE by initial absence of initial evidence, sponsoring spouse not having sufficient income, or legal entry proof was not in the packet, or missing translation of documents. That's another one. It could be a myriad of things. I think I see a lot more RFEs when an individual files on their own and they don't do this on a regular basis, but it also could be just something simple. Now, I will tell you that if you submit your adjustment without the medical exam, they will send you saying it's deficient, but that's not the same thing as a request for evidence. And but request for evidence is usually asking for something that you should have had in the first time, or maybe something a little addition they're trying to update. So what do you do when you get the request for evidence? Well, first of all, you read it. You don't panic. You take a breath, right? You read it and you strategize. And then you start collecting that evidence. And sometimes you go back and look at the original packet and you say, I thought I did submit that. What are you talking about? And that could be the case. Sometimes they ask for things that were already submitted. And you're just like, okay. The craziest RFE I think I ever saw was one where they asked for an English translation for like a British birth certificate. It's in English. I don't know. So anyway, so sometimes it can be surprising, and you might not be able, you might be like, do a double take. So read it over with a cool mind, review it, maybe have someone else review it too to see if you're reading the same thing. And then, ultimately you want to respond with everything they're asking for by the deadline, right? And maybe if you don't have everything or can't obtain it, then you need to say why you can't obtain it. And so you could respond to the whole thing, partial response, respond to what you do have, and withdraw the application, a petition. I mean, that really only happens if you're like, oh my, I probably shouldn't have filed this in the first place. They're asking for some things that I can't get, and maybe I'm not even eligible. We don't withdraw that often, but if sometimes we might have to withdraw a petition. So you want to make sure that you completely answer and give satisfactory answers so that you can respond and get a positive result at the end. Now, when the request for evidence wins, then the best approach to withdraw and resubmit. Well, it could be, you have to look at the timing of everything, whether the regs require establishing eligibility for the requested benefit. It could be changed circumstances. Maybe there's new evidence available now. So you sort of have to take a look at it. Maybe the person didn't qualify at the moment it was filed, and the RFE is making them realize that. And if you then submit it later, like, let me give you an example. A DACA risk application, you're supposed to be have a GED, have a military meter requirement, or be in school at the time or something like that, right? Well, there was some times where people were not in school at the time of the filing. They'd get a request for evidence, and then they would show a date that they had just joined school later. But then they later denied the DACA, saying, no, you didn't meet the qualifications at the time. And then that merited filing another DACA saying, like, now we meet their qualifications later on. Hopefully that made sense. But I'd say definitely talk to an attorney before you withdraw something, just to make sure you have your strategy straight. Now, what's a NOID? A notice of intent to deny is a notice that USCIS sends to inform them that they're planning on denying it. It's like a heads up, like, hey, I'm about to deny this guy. And you're like, what? Freak out mode a little more than the RFE, because they're pretty much 1 foot already into the denial mode, right? An RFE, like, that could go any way. So you got to really look at this and say, it's the same approach as the RFE though, even though it seems a little more serious. Look it over, figure out what's going on, and whether it'd be better to respond or withdraw the application. And yeah, exactly what I say here. It's more of a serious version of an RFE. The reason for issuing the NOID rather than simply denying is to give you to outline the reason and to save you both money and time. So this is very generous of them, because if it was a denial, you would only have either refiling or appealing pretty much, or some advocacy to reconsider. So this gives you a little bit more time to advocate. So how to reduce the risk of getting annoyed and annoyed by getting annoyed. I think I could do this all day. Is, just make sure you don't misrepresent a material fact, that nothing is incomplete in the application, and that you make sure you're eligible in the first place. It could be potentially that they think there's marriage fraud or something. That's not a good thing, but you definitely want to make sure that you present your best case and your foot forward as much as possible. So, or it could be about crimes or something like that. That can be a problematic if you get arrested for something in the middle of applying for something. And then it might need to be held in abeyance while you're waiting, instead of them just denying or just the case altogether. So just try to put your best foot forward initially. If you do get annoyed, make sure you read it, strategize, look it over, double check what you submitted, and have another set of eyes review and prevail. And usually they'll give you 30 days respond. And then as we went over the policy memo, you can have another 60 days. So make sure that you do your best in your response. Now, when is the NOID better to withdraw and resubmit? Well, take a look at the denial notice. Will provide information whether decision may be appealed or not, but we might not have the denial yet. We might still be at the NOID stage. But so if it does get to denial, then you can either appeal or refile. Generally, there's some applications, very few, that are limited to how many times you can file. I could think of the N600 has little peculiarities to it, but like other ones like N400, ISIN-51 adjustment, like there's no limit to those. And some motions to reopen, which we're really not talking about today, can be time limited as well. So just double check it's not time limited, double date limited, number limited, and that you've reviewed all your possible options and made the best decision. But for lots of cases, you can just reapply. You just waste a little time in filing fee, maybe legal fee. So that can be a little annoying, but overall, it might be the necessary steps to going forward. Now, this is where it gets a little bit scarier when the notice of intent to revoke. It's basically saying we want to take away something that we already gave you before. Something that you were given and you relied on and you thought that this was mine, and then now you see that they're saying this, and so this puts you in a tough bind because well, you got to look at the situation. Are they wrong? Hopefully they're wrong, and you can just turn around and say, hey, you're wrong and this is why. Here's a whole bunch of evidence. Boom, 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 boom. If they say that if you know that they're right, then you got to quickly think about what's your backup plan. Because generally when that notice of intent to revoke, when they actually revoke, then that's when it's going to go into effect, and then you have less options to respond. So this could be like if for an I-130, if they later find out that there was marriage fraud. This could be for naturalization if they find out there was a mistake. This could be for like a green card if someone filed the application before the visa was available. This could be for lots of different scenarios. So what do? You review it thoroughly, like everything else. You take a breath, you review it thoroughly. You try to see if it's USCIS's mistake or your mistake. You go back generally to your past applications and double check, was everything done correctly? You identify the issues, and you definitely want to respond, especially if you want to fight this. And maybe even if you're potentially wrong, but you think there might be a chance. It's always worth fighting if you think that there's some merit to it. So you would want to respond. Now, filing an amendment to a petition to correct any mistakes, these petitions can be filed with a request to nunc-pro-tunc. Nunc-pro-tunc, it's fun to say, it's hard to spell, and people don't know what it means. But basically, I don't even know what it really means in Latin. Maybe Dia can Google it. But it's basically like saying, put me back where, let me file now that I'm on this, I'm putting myself on the spot. I do these all the time. Okay, so the nunc pro tunc, it's like saying, can we file it as if it was at the time of at that moment, to try to put me in whole, and sort of excuse my late filing, but also put me back to the initial filing. So which DHS, where you're asking DHS to apply the changes to initial filing. Okay, that's what I'm basically saying. And what's nice about that is that then you could have said you had status the whole time, you didn't accrue unlawful presence. There's lots of benefits to that. And so that's why you would want to do that. And so anyway, those are ways that you could do that. So nunc pro tunc is a phrase used in order or a judgment when the court wants the order or judgment to be effective as of the date in the past. So going way back there, rather than in the date that's right now. And we do a lot of those when people miss the filing deadline for some particular reason and have to go back, especially with like change of statuses. And we've been successful if you can have good compelling reasons. So once you submitted the rebuttal to the notice of intent to revoke, prepare for a lengthy waiting time because this is complicated. Somebody's going to have to look it over, and it could be a while. If you gather new evidence while you're waiting, you could try to supplement it. And if you don't like the results of that answer, then you usually have a chance to appeal, or you might want to file again, depending, but consider all the consequences of that. So in conclusion, try to avoid requests for evidence, notice of intent denies, and notice of intent to revokes, obviously. But hopefully we got you some ideas on how to do that. Be as prepared as possible, be as thorough as possible, keep copies of your records. So seek help immediately. When I tell my staff that if we get a call and somebody's like, I need to respond to an RFE and notice all these things, right? All the letters. I was like, get them on the calendar as soon as possible because timing is of the essence. And so when you call someone, make sure you say, hey, I have a XYZ RFE and I do NOID, a notice of intent to revoke, and it's due soon. Can I get on the earliest appointment or make, be on the wait list or whatever? Don't delay in seeking help because even same thing, we'd have to review it. We have to look at the past applications. We have to strategize. We might have to do some research, and then boom, we have to get ready and file. A lot of times we're trying to cut off getting a notice to appear to go to immigration court, and that's why we want to file as timely as possible. And I think it's good to try to stay positive. And definitely find an experienced immigration attorney that can help you and you feel safe and confident with if they're giving you the best advice possible. And I had a similar case that they can bring their experience to the table to help you as well. So I think that was our overview. Daya, how can they stay in touch and what more can we share?
Oh yeah, so we actually on our TikTok, we have a few videos regarding RFEs. They're not as serious and they kind of help you lighten the mood, just Ruby being funny per usual. So if you want to see those, go ahead and go over to our TikTok at Powers Immigration Lawyer. We're also on all this other social medias. We're on Facebook, Twitter, Instagram. We also have a LinkedIn, and then we also have a newsletter. You can find all that information on our website. And then so next week's webinar is going to be ways to expedite your case with USCIS, which is going to be some good information for everyone. But thank you all for joining us today, and we would look forward to seeing y'all next week.